Hello friends, good noon to one and all. I Advocate Sunilesh Doshi welcome you all for today's webinar by Honorable Justice V.M. Kanade sir. It's my honor to introduce Advocate Vasantaram Lawyers Training Center, which has been established by Sangli Bar Association with the great support of senior and junior members of the bar. It is a unique center which has been established in the name of Advocate Vasantara Patil, who was a renowned criminal practitioner at Sangli. He was also the president of Sangli Bar Association. Sangli Bar vigorously takes initiative for such activities and members always support unconditionally. This training center was established with purpose to boost the confidence in the budding as well as the practicing lawyers, to impart knowledge, inculcate discipline, and overall personality development of the advocate is our motto. And in the past, we have held many such lectures to achieve the same. Thank you so much, Kanade sir, for joining in. Now over to Abhinandan Shetty. Thank you.
Thank you, sir. Good afternoon. Today, I have the honor to introduce great personality in the field of law. In fact, our guest today does not need any introduction. His long, illustrious career in the field of law, both as an advocate as well as a judge, is testimonial to this. Well, friends, I present you my Lord Justice, retired Kanade VM sir. Sir started his practice in Bombay High Court in the 1979. Hello.
Yes.
Yeah, June 1979. And he dealt in civil, criminal, as well as constitutional matters. He was AGP in Ritsel from 1968 to 1990. And he was High Court Panel Counsel for Union of India from 1986 to 1989. He was Panel Counsel for State of Maharashtra from 1992 to 2000. He was he represented various government, represented number of educational institutions. Sir also maintained a lot of lawyers, and for that he was actually visiting professor in the Department of Law, Mumbai University from the year 1992 to year 1995. And prior to that, as from year 1985 to 1991. Sir was elected as High Court Judge of Bombay, illustrious career as High Court Judge. Lawyers, especially junior lawyers, he was very kind, encourages, as well as he was calm and patient. He was compassionate. Sir was chairman of Mediation Committee of High Court of Bombay. He was executive chairman of Maharashtra State Legal Services Authority, Mumbai. He was acting Chief Justice of Bombay High Court. Now, friends, this list goes on long and long, but I'm very well aware that you are eager to listen to our illustrious guest. So, I humbly request today's guest, Justice Retired Justice Kanade sir, to address the webinar, sir. Over to you, sir.
Good evening, all of you. It's my privilege and honor to address all the members, lawyers, and guests, the members who have come here. And I must congratulate the Sangli Bar Association, first of all, for organizing this webinars and lecture series. I personally did not have the privilege of meeting Advocate Vasantarao Patil, but I have heard about him. He was an eminent lawyer in the Sangli Bar and also was quite well renowned in the state of Maharashtra. I am quite sure that this program which we have started of webinars during this COVID period and lecture series will be immensely beneficial to all of them, to all the junior lawyers as well as practicing lawyers and even senior lawyers. Because we cannot forget one thing, that though we obtain a degree of law after completing our LLB education, we remain students of law throughout our life, because law is such a vast field that no matter how much you study,
Sir, can you please unmute yourself? Accidentally, you've been muted. Yeah, we can hear you now.
eminent personalities like Palkiwala, Sirvai have all said that they have been students of law and will continue to be students of law throughout their life. And therefore, I once again congratulate the Sangli Bar Association for organizing this training program. Now, today I have been asked to speak on the subject of quashing of criminal complaint. This is a vast subject, and I would like to touch all aspects of quashing of criminal complaint. Now, normally, all these complaints for quashing are filed in the High Court. As a matter of rule, in fact, it can be only quashed by the High Court, either under Section 482 of the Code of Criminal Procedure or under Article 226 of the Constitution of India. Now, what I propose to do is this. I would like to discuss the subject in three parts. First part will be relating to the historical background of CRPC, English law, Indian law, the various amendments which have been made, and the of CRPC.
Sir, can you unmute yourself again?
Yes, yes. And then again, discuss the provisions of Article 226, under which a criminal complaint filed before a police officer, a FIR, can be quashed. A brief background of the power of the High Court under 226 and 482. And thirdly, the case law on this point, how the law has developed over a period of time. There are various facets to this question of quashing of complaint. Normally, a complaint can be quashed by the accused on several grounds. But sometimes, in some category of cases, a complaint for quashing can be filed by the consent of the complainant. So what is the law on that point? Because we find that there are several cases where the victim is, though she is willing and has given her consent, is below the age of 18 years, and the consent therefore cannot be accepted because that consent is not a legal consent. And therefore provisions of POXO are attracted, and even if the girl and the boy get married, the boy goes behind the bars. And there is a difficulty on account of the new act which has been passed, the POXO Act, where this complaint, even if there is a consent, becomes very difficult for the High Court to quash. So, a large number of cases now we find under this category. Second, there are instances where initially there was consent but a complaint is filed either to take vengeance. There is a living in relationship which is now recognized by the statute. And if there is a quarrel, a complaint is filed, but later on the parties settle the dispute, and then a complaint for quashing by consent is filed. So these facets I'll try to cover as far as possible in this time which has been allotted to me. Now let us go to the historical background of CRPC. You see, uh, so far as criminal law is concerned, we have inherited this from the British system, Anglo-Saxon system of criminal jurisprudence, which is pretty old and which has evolved over a period of time, over almost 500 to 600 years. It evolved in England. And a procedure was evolved for arrest of accused, for production, then for filing of report, admissibility of evidence, admissions given before the police, and therefore it has taken a long time for the criminal procedure to evolve. Sometime in 1860, the Indian Penal Code was enacted by the British Parliament. There about the same time, CRPC, Evidence Act laws were passed and they were made applicable to India. Now, even though the British ruled this country, Macaulay, who was the person who drafted most of these acts, took care to ensure that the judiciary doesn't put its entire faith on the executive. And therefore, several safeguards have been introduced in the CRPC. CRPC, if I am not mistaken, was passed initially in 1888, and thereafter it has been amended from time to time. Several times it has been amended, though IPC provisions and the sections have not been amended as extensively as CRPC. So CRPC has undergone a lot of change as judgments of the Supreme Court and earlier judgments of the English courts were passed, and upon recommendations made by the Judicial Commission, several amendments have been made. Now it is necessary to understand the philosophy or the scheme behind the CRPC. You will find that though the British ruled India, they ensured that unbridled, unfettered power was not given to the police machinery, because it is well known that absolute power corrupts absolutely. And therefore, at each and every stage, the statute has ensured that there is an intervention by the judiciary, by an independent person who can ensure that the police do not misuse the authority which has been given to them by law. And therefore, we find that right from filing of a complaint under Section 154 to the completion of investigation, and also while exercising the power of arrest in the case of a serious offense, the accused has to be produced for the magistrate within 24 hours. The FIR has to be, copy of the FIR has to be given to the magistrate. Otherwise, adverse inference can be drawn if there is a delay, and it can be presumed or it can be argued by the defense that the FIR has been fabricated. Same is the case with filing of a charge sheet under 173. And even after filing of the charge sheet, Section 173, subclause 8 authorizes the police to continue their investigation if fresh evidence comes to light. But then the Supreme Court has said that in respect of further investigation also, though there is no provision of taking previous consent of the magistrate, the Supreme Court has said that courtesy demands that the judge, the magistrate who is overseeing the course of investigation, not in the direct sense, but is observing what is being done, has to be informed by the prosecution, and a formal permission has to be applied. Normally, whenever such application is filed, the application for further investigation is granted. But the point is that the Supreme Court has observed that even if there is no provision, as a matter of courtesy, the prosecution has to approach the magistrate before continuing the further investigation. And recently, of course, several amendments have been made after 2009 onwards. And now we find that there is a victim-centric approach to the investigation and in respect of his right to file an appeal under 372. So, to some extent, amendments have been made because at one time the emphasis was on a fair trial. Now, one might wonder why such an attitude has been given to the accused. And some even go to the extent of saying that this is pampering the accused and forgetting the victim. But I believe that in India, we have what is known as the rule of law. And rule of law demands that the person, the authority, has to follow whatever has been prescribed by the law, and his personal whim and fancy is not relevant and not a guiding factor, but he has to go by the rule of law. I remember, just incidentally, I must tell you that I remember that some time back, a judge of the Kerala High Court had remarked that if a person commits forgery, then his hand should be cut. After the Nirbhaya case in 2012, there was an uproar, and a number of people felt that sentence of life is not sufficient, and therefore these persons should be castrated, their genitals should be removed, they should be hanged in public. But one has to remember that such opinions are personal opinions, and they cannot be translated in an actual punishment or sentence, because we are governed by the provisions of the Act. Section 375 and 376 lay down what the judge can do and what kind of sentence he can impose on the accused if the guilt is proved. So therefore, we have to realize that even the British government had ensured that excess power, unbridled power, unfettered discretion is not vested in the police machinery, because it is always easy to for the police to abuse the process of law, to misuse the power which is given to them. And therefore, I believe for the purpose of a fair trial, fair inquiry, it is necessary to give some rights to the accused. Now one might wonder why and how did this evolve. See, over a period of 500 to 600 years in England, several archaic and drastic provisions, draconian provisions were there. And about 600 years ago, the provision was that the accused could not appoint a lawyer, and he was produced before the priest, and they could pronounce him guilty by putting a heated rod in their hand, and if he was scalded or burned, it would prove that he was guilty, because if he was not, God would have saved him. Such kind of archaic rules and procedures were established earlier in England. But as democratic principles evolved, it became necessary that the accused had a right of cross-examination. I believe the first lawyer was born during the biblical period when there is a reference in the Bible. It is said that there was a Roman Senate and a person was unjustly arrested. His wife went to the Senate members and she pleaded that he should be released. They asked for some favors from her, which she refused, being a chaste woman of chastity. And immediately thereafter, they also pronounced her guilty. And in those days, the sentence was death by throwing stones at the accused, stoning the accused to death. So when she was brought before the public at large, and the Senate members said that does anybody have any objection? So one young man got up and said that he would like to ask some questions to the Senate members, and that too separately. Reluctantly, looking at the crowd, and the crowd also said that yes, he should be given an opportunity to ask questions. So reluctantly, the Senate members agreed. So he questioned one by one all of them. He asked them at what time this lady had come, what were the clothes she was wearing, what was the demand made by her, and he established, and then he would send the first person back and call the second Senate member. Obviously, all this was a figment of their imagination. And therefore, there were several contradictions in their statement when questions were asked by that young man. And eventually, when all the senators were examined, it became very clear to the public at large who had gathered there that these Senate members were lying and the woman was innocent. And these members were stoned to death. So that was the birth of the first lawyer, criminal lawyer, and first cross-examiner. For a long time, this art of cross-examination or the right of cross-examination was not given to the accused or the defense. And only in the late 17th and 18th century, liberty was given. There was a provision made for cross-examination by the defense counsel. So cross-examination is an important tool in the hands of the defense to ensure that the truth comes out. And that is how, in one way, the criminal law evolved. Several amendments were made in 1973, and thereafter again, I believe in 88, 87, 88, and now recently in 2009 to 2013. So this is the brief background of the scheme of the CRPC. Now you will find that though there are several chapters in respect of arrest, surety, filing of complaint, etc., there is also one provision which has been made, which saves the inherent power of the High Court, and that is under Section 482. So the section says that notwithstanding anything contained in the Code of Criminal Procedure, the High Court has the inherent power to do any act in the interest of justice. I will notice here that no guidelines have been given as to how this power has to be exercised. But this power over the years has been interpreted by the Supreme Court in several judgments, and the law therefore has now evolved over the last 30 to 40 years after Constitution came into force. Now, of course, one might wonder, why is it necessary to give this power to the High Court for the purpose of quashing a complaint? When I was a junior lawyer, I was on the criminal side, I was practicing with Shamrao Samant, whom we affectionately called as Dada. He was an eminent criminal lawyer, and he was a public prosecutor for a long time, and he had practically appeared in all uh, criminal cases for almost 20, 30 years, including the famous Tomi Nave's Kazi case, Joshi Abhyankar case, General Vaidya case, and several other cases. And later on, he became a defense lawyer. So once I asked Dada that, Dada, why is it that the police would fabricate evidence? Why is it necessary? So he told me that, look, ultimately police officers are human beings. They have a job to do. And there is an obligation on him, on the police officer, investigating officer, to ensure that he gets a conviction. In the olden days, if an accused was acquitted, that would be put in his diary, in his service record. And therefore, he would ensure that the witnesses do not turn hostile. It was his duty to ensure that police protection is given and he is not won over or threatened by the defense and their witnesses. So, therefore, they made utmost effort to ensure to get a conviction. Very often, the standard method adopted by the police to extract the truth was to beat the accused in custody, resort to third degree method, and obtain a confession and then create a record. And sometimes the police officer was convinced that this accused is guilty, he has committed offense. And therefore, he felt that the missing link between the investigation could be filled in by fabrication of evidence. And therefore, I am sorry to say that those judges who have never practiced on the criminal side are not well equipped to see the uh, prosecution side and what they are capable of doing. I remember when I was a lawyer practicing in the Bombay High Court, there was a judge who was promoted as a High Court judge. He was a district judge throughout his life. So he would ask the lawyer appearing for the accused who was arrested and was seeking bail, कि तुमको क्यों पकड़ा, मुझे क्यों नहीं पकड़ा? So some of the senior lawyers mischievously would say among ourselves that he has galti kiya. So this was the kind of approach very often of judges who never practiced on the criminal side and did not have an open mind. And I am sorry to say that very often public prosecutors also have that kind of feeling that what the police do is correct. I remember a little digression. I remember in 2003, there was a delegation from China. The Chief Justice of the Beijing High Court and all his colleagues and session judges and magistrates had come to the Bombay High Court, the delegation. Our Chief Justice was Chief Justice Thakkar. And there was an interpreter who would interpret the questions which were asked by respective Chief Justices. So our Chief Justice Thakkar, asked a question to his counterpart. He said that in India, we have a doctrine which says that the accused is presumed to be innocent till he is proved to be guilty. So do you have such a doctrine? So this was interpreted to the Chinese Chief Justice from Beijing. He thought for a moment and he said, yes, we have this doctrine. He is presumed to be innocent till he is arrested by the police. So there in China, in Japan, the procedure is that as soon as the police complete the investigation, presumption is on the evidence produced by the prosecution. And in Japan, there is a 99% conviction. So in China, for some minor offenses, the trial, I am told, I may be wrong, but trial is held by a computer, where the facts are feed in, the computer gives a judgment. So I believe that to a large extent there is a possibility of abuse of process of law, and therefore, though our system is very slow, yet it is necessary to ensure that there is a free and fair trial to the accused. So, therefore, now having given the background of CRPC and scheme of CRPC, let us go to the second topic, which is the provisions, relevant provisions of the CRPC, which are necessary to examine the question of quashing of a criminal complaint. Now, as you are all aware, being lawyers practicing in trial courts and also appearing in high courts, that the magistrate can take cognizance of an offense under section 190 of the CRPC. Now, there are three types of complaints which can be filed. One is on a police complaint or a police report. Second is by the complainant. He brings the fact before the magistrate by filing what is popularly known as a private complaint. And third is that officer. There are several acts where police complaint cannot be filed, but a complaint has to be filed by the officer who has investigated under that particular offense, particular act, and he files a complaint before the magistrate, such as under the Prevention of Child Labor Act, Labor Acts, several other acts where Customs Act, where the officer files a complaint before the magistrate, and the magistrate can then take cognizance. Now, these are the three provisions. So far as police complaint is concerned, the procedure is laid down under CRPC, starting with 154, ending with filing of complaint, and then if it is a warrant trial, then the evidence, how it is to be led by the prosecution, etc. Then we have other procedures like summary procedure, summons case procedure, etc. So that procedure has to be followed. Now you might be wondering what happens in respect of a complaint filed by a complainant before a magistrate. There are instances where, again, this is a safeguard which has been provided. Suppose a politically powerful person commits an offense and he has some connection with the police and he ensures that the FIR is not registered. What does the person, complainant victim, do? He can then approach the magistrate and file a private complaint, point out what are the evidence, what are the facts, establish that the facts mentioned by him constitute a cognizable offense, and then the magistrate can take cognizance by issuance of process. The procedure is laid down under section 200 onwards, where he can examine the complainant, examine his witnesses, and then if he comes to a conclusion that perhaps a case is made out, he can then issue summons or what is known as process. So same is the case in respect of a complaint filed otherwise than on a police report. So the magistrate has ample discretion, but once the criminal law set in motion, there is no turning back. And therefore, by way of abundant caution, I believe that there is no separate procedure laid down under the CRPC for quashing of complaint by the magistrate or the sessions judge. That power is residual power, I would say, but an important inherent power has been given to the High Court. Because if you remember that as after independence, the number of cases which were filed in the civil court increased. Cases for recovery of money, cases for recovery of possession, for mortgage being annulled, and several other cases, specific performance, etc. But unfortunately, because of the pendency of the cases, these civil cases were never resolved, decided finally, because after the trial court decided to go to the district court, or if the district court decided to go to the high court, then to the, in those days we had letters patent appeal, and then to the Supreme Court. So it would take 15, 20 years. So ingenious, I would say, lawyers or ingenious litigants then found out a way to harass or resort to arm twisting of the person who was liable to pay them money. And the easiest way to harass him was to file a false criminal complaint. Because once a criminal complaint is filed and cognizance is taken by the magistrate, the criminal law, the process of criminal law is set in motion. And then he is arrested. People are afraid of the police in a cognizable case. The police can arrest without warrant. He can be kept in a police lockup after remand order is passed from time to time for a maximum period of 14, 15 days. And he can be tortured, he can be harassed. And many people are afraid, and they would, after criminal complaint was filed, settle the matter, the civil matter, and pay off the dues or arrive at some kind of arrangement for the payment of those dues. Possibly understanding that there was a possibility of misuse in respect of the criminal powers which are given to the, which are powers which are given to the police under criminal law. Section 482 was incorporated. You will also find that a similar provision of inherent power of the High Court is found in the Civil Procedure Code 451. So this is a residual power where you cannot contemplate a situation which may arise where there is injustice. In such cases, therefore, the High Court is armed with the power of ensuring that proper justice is done and that the accused is not made to go through the rigmarole or the procedural hassle of having a hanging sword on his head and dealing with the police and the witnesses of the complainant. So, therefore, 482 would be resorted to. There is another provision under which a complaint can be quashed. Now, of course, that is in the respect of a first information report, and the Article 226 of the Constitution of India, an FIR can be quashed by the High Court while exercising its writ jurisdiction under 226 by issuing a writ of certiorari or prohibition, asking the lower courts not to proceed further, to stay the further proceedings, and asking the police to quash the FIR which has been registered. Very briefly, I'll just narrate the powers of the High Court under 226. See, under Article 226 of the Constitution of India, the High Court has a power to issue writs. There are 5 prerogative writs: writ of mandamus, writ of certiorari, writ of prohibition, writ of habeas corpus, and one other writ. So these 5 writs can be issued by the High Court. Over and above these 5 writs, the High Court can also issue directions and pass orders directing authorities, state authorities, instrumentalities of the state from doing or abstaining from doing some kind of action which they propose to take. And so therefore, under Article 226, in a case of a patent irregularity and in respect of cases which we'll discuss a little later, the High Court can issue a writ, stay the criminal proceedings, stay the investigation, and then ultimately, after the affidavits are filed, and if it comes to the conclusion that this is a fit case for quashing the FIR can be quashed under Article 226. Initially, it has been held that this is a power which should be used very rarely and only in certain circumstances where there is an abuse of the process of the court. And only in such circumstances, Article 226 can be used. As my experience in the High Court, as a judge sitting on the criminal side for quashing of complaints, I have noticed that very often, several frivolous complaints are filed. And we have to draw a line where deciding in which case, of course, the case law I'll discuss a little later, which discusses when and under what circumstances a criminal complaint can be quashed. What happens if there is an alternate remedy of filing a criminal revision application before the Sessions Court in a private complaint where process is issued? Would it be a bar for the High Court from entertaining? So all those issues we'll discuss a little later. But therefore, the power of the High Court under 226 is quite vast, and in a given case, it can always exercise its writ jurisdiction and quash that complaint. Now, let us go to the third part, which is before we discuss the case law, about quashing of criminal cases by consent. Very often, as a judge sitting on the quashing assignment, I have noticed that complaints are filed out of vengeance in the heat of the moment, and later on parties settle the dispute. And particularly under 498A, there are several judgments of the Supreme Court where Supreme Court has given directions to the police not to promptly file a complaint and arrest the husband on a complaint being filed, because very often it is filed out of vengeance. Of course, there are a number of cases where this is true. The allegations in the complaint are true. So the police have to make a preliminary inquiry and then arrive at a conclusion whether this is a fit case for filing of FIR and arresting the accused. So therefore, I noticed that there are several cases, and the Supreme Court in Gyan Singh has considered the two judgments of the Supreme Court where there was a difference of opinion, B.S. Doshi and one other judgment, where it was observed that if a case is not compoundable, then the High Court cannot exercise its power of quashing because the statute has prohibited. So what happens in such cases has been discussed at length in Gyan Singh. I must point out that firstly, I would like to discuss cases under section 376. Now, of course, where it is found there is evidence that the victim prosecutrix has suffered grievous injuries and was physically assaulted or murdered, and later on an application is made for quashing, then in Gyan Singh, a word of caution has been given by the Supreme Court that in such cases, even if the complainant or his family members have come forward saying that they want to, by consent, quash it, the High Court should not interfere because it is an offense essentially against the society. Public outcry is also an element which has to be taken into consideration by the court before quashing that complaint. And therefore, serious economic offenses like murder, offenses of attempt to commit murder, are some of the cases where the Supreme Court has said that even if there is a consent, the High Court should not use its discretionary power to quash a criminal complaint, a serious criminal complaint. But in number of cases, it is found that the accused and the prosecutrix had relations, and there was a consensual sex. And after some time, when the accused either did not accede to the requests or demands made by the prosecutrix out of vengeance, complaint is filed. There have been reported cases where the accused initially had promised to marry the prosecutrix, but later on, because of some dispute, he refused to marry her. And on that ground, that because of the promise given, the prosecutrix had given her consent to have sexual relations. But because later on he refused to marry, there was a breach of promise, and the consent was given on the basis of the representation made by the accused. The Supreme Court, in couple of cases, has held that break of promise cannot be a ground for filing a complaint. Breach of promise, therefore, is not a ground, and Supreme Court in a couple of cases has quashed the criminal complaint. Secondly, now over a period of last 2 decades, there is another phenomena which is found in the society that is known as living relationship. That without getting married, the couple starts residing together for a number of reasons. And after some time, the living relationship has now been recognized by the statute under the Domestic Violence Act. There is a provision that what is a living in relationship has been defined under the Act. And what are the consequences? Whether the partner, the wife, so-called wife, who has agreed to have live-in relationship, can claim maintenance. So these are now accepted, relations are accepted by the statute. Now what happens if after a couple of years of staying together, the lady then says that he had promised to marry me and had committed rape on me? Would it fall within the definition of rape? And whether such a case can be quashed by the High Court. I remember a case where the woman, a young woman, herself filed a complaint for quashing a criminal complaint of rape. In that case, she was living in the relationship with a businessman, and after some time there was a quarrel between the two, and then she filed a criminal complaint of rape. The police had no other option but to arrest him, and he was in jail for about 8 months. And she filed a complaint. The matter came up before me. The question was that the woman would have been prosecuted for giving false evidence, for filing a false complaint under the provisions of 191, 192, 182, or 192 of the CRP of the Indian Penal Code. But I said what is important is that she is virtually admitting that she had filed a complaint in the heat of moment. And it was necessary to save that poor chap who was behind bars. So I gave a direction to the police officer that you immediately produce that man in the court at 3 o'clock after recess. So he was produced. That lady said that I filed a complaint in the heat of the moment, and I wanted the complaint should be quashed. I exercised my power under 226 and 482 and quashed that complaint. And I told the police officer that he should be released from the court immediately. The police officer said, no, he has to be taken again to Arthur Road jail, where his signature has to be taken. I said, nothing doing. You bring that register to the High Court. Get his signature here. I don't want him to stay in prison for one more single day. So it depends on the view of the court as to how the court takes that view. Another type of cases which have come up before me are cases where the victim is below the age of 18 years. Now, the term consent has been defined as a consent given by an adult who is 18 years and above. So technically, a girl who is below 18 years of age, even if she has given her consent, that consent technically is not acceptable. And then the law treats that offense as rape. Now, this was a case where the girl was 17 and a half years old. And the boy was 23 years old. And he was doing his engineering, coming from a good family. They were in love. And she said that let us elope and get married because my father is looking for other boys and he doesn't approve of this marriage because the boy belonged, though both were Hindus, but they belonged to different caste. So she insisted that let us not wait. Reluctantly, the boy acceded to her request. They eloped, got married. The father of the girl was very angry. He filed a complaint. He filed a complaint. The boy was arrested. He was behind bars for 2 months. He lost that year of engineering. And later on, the father realized that the girl was in love. By that time, she had already completed 18 years of age. She said that I will not marry anyone else. I am already married. And so therefore, I want that this complaint should be quashed. So the father reluctantly filed or willingly filed a petition for quashing by consent. So I realized that this was an unfortunate case. That though technically it was rape, the girl herself had given her consent. And she was still willing to stay with him as his wife. And so I asked again the superintendent of jail to produce him before the court. And I asked him that don't you realize that marrying a girl, falling in love is not an offense, I said. But to marry a girl who is a minor without the consent of the guardian is an offense. And you could have waited for 6 months. So he narrated that this is what has happened. And I was compelled to marry her because the father was likely to get her married elsewhere. See, under the Guardianship and Wards Act, if a girl is a minor, then with the consent of the guardian, the marriage can take place. Of course, now Supreme Court Justice Lokur has taken a very strict view of the matter and has said that it amounts to restraint of Child Marriage Act and therefore it is an offense. and such a consent cannot be given by the guardian. Even if the guardian has given a consent, that cannot be accepted. So next day, of course, the media is very mischievous. As a lawyer and as a judge, sometimes you have to be very careful. And on the next day, on the front page, some of the newspapers reported that, quoting my quote, that falling in love is not an offense. Justice Kanade. They did not, however, mention the second part which I had mentioned, that you should not marry a minor without a guardian's consent. So very often the media plays a role. Today is not a time, maybe some other time I'll like to talk about the role of the media in influencing the courts and the public at large. So therefore, this second category of cases are on the rise. And you see, what is happening is that girls have become very matured at a very young age of 12, 13, 14. And they understand everything. They are matured enough. They know the consequences of their action. And they take their own decisions. So Justice Vardharajan, Vardharajan, there was a case in the Supreme Court where Justice Vardharajan held that if the girl is matured enough to understand the consequences of her action, and if she is almost a major, then offense of rape cannot be held to have been committed. Relying on that judgment, I quashed that complaint, which was filed by the father of the prosecutrix. And so very often we have to take a practical, pragmatic decision. And sometimes police are bound by the law and they are afraid that if they don't take any action, their services are likely to be terminated or they are likely to be suspended or an inquiry can be held against them. So the only resort in such cases is to approach the High Court. Now, time is short and therefore I'll go to the third topic, that is the judgments of the Supreme Court and High Courts on this issue. So law has evolved over a period of last 40, 60 years, 50 to 60 years. The first judgment which can be found, which the Supreme Court has given, is in the case of R.P. Kapoor versus State of Punjab. There, the Supreme Court has laid down the law and pointed out the circumstances under which this particular complaint, criminal complaint, can be quashed. So there are in R.P. Kapoor, Supreme Court made a classification and laid down that in three types of cases, a criminal complaint, a police complaint can be quashed, or a private complaint can be quashed. The first category is that the facts mentioned in the FIR or the private complaint do not constitute an offense, even if they are taken at its face value and even if they are accepted as correct. Even then, no complaint is constituted and the ingredients of that offense are not found. So this is a fairly simple way of ensuring that you read the complaint, FIR, don't go to any other documents and other things, and see whether the ingredients are to be found. And if it is not found, for example, if the complaint is such, there were a number of cases, of course now the law has changed in respect of atrocities committed on scheduled caste and scheduled tribes. And Justice Lodha, when he was in the High Court, the former Chief Justice of India, in a judgment in the High Court had said that if the complaint does not constitute an offense, then the complaint can be quashed. What are the ingredients of the offense? Is that it should be that abuse has to be, the accused has to be, the victim has to be abused in the presence of the public. What kind of abuse? Abuse in the name of his caste, etc., etc. But of course, later on, the Supreme Court said that no, this can't be made applicable to offences under prevention of atrocities of scheduled castes and scheduled tribes. So very often this arm twisting mechanism is used. There are other nice judgment of the Supreme Court in case of Pepsi Cola. Her Ladyship Justice Sujata Manohar and Justice Wadhwa have given this judgment, in which they have said that it is not necessary for the accused to go through the trial and get an order of acquittal or apply for discharge, because the provisions of discharge are that way very limited. And therefore, the Supreme Court said that if it falls under any of these three categories, or the second category is that a criminal complaint is expressly barred by any statute. Now, there is a provision which says that a criminal complaint cannot be filed, then in such cases also the High Court under 482 or 226 can quash that complaint. And the third category, which has been classified in R.P. Kapoor, is a case where there is no legal evidence. What do you mean by legal evidence? By legal evidence, it means that evidence which is not admissible in any court of law, and even if given, does not have legal value. So these are the three categories of cases mentioned in R.P. Kapoor. Later on, in the case of State of Haryana versus Bhajan Lal, the Supreme Court increased the number of categories to 7. One of the categories was the complaint is filed with a mala fide intention, that it was motivated to take revenge. This was a case where criminal complaint was filed by Bhajan Lal against former Chief Minister Devi Lal, and several allegations were made. The High Court came to the conclusion that the case for quashing was made up, and the complaint was quashed. Supreme Court said that no, there was no material for quashing of the complaint, and the High Court had erred in exercising its writ jurisdiction and inherent jurisdiction. But it laid down several categories where, of course, one can notice, except the mala fide complaint, the others are split up from the three major complaints, major classifications which are found in R.P. Kapoor. So more or less, it's just expansion of the basic idea which is found in Bhajan Lal, which is found in R.P. Kapoor. Later on, several judgments have been delivered, enunciating the rights of the High Court under 226 and when and how, under what circumstances it can be exercised. Later on, in one judgment, the Supreme Court in B.S. Doshi versus State, I don't remember the other party, B.S. Doshi versus State of Maharashtra. Supreme Court, our former Chief Justice B.P. Singh, was then by then had become the judge of the Supreme Court, said in his judgment that was a case where there was a matrimonial dispute. Application under 498A was filed. Later on, the matter was settled, and they filed an application for quashing. The prosecution came out with a case that this is a non-compoundable offense. At least it was then at that time. And therefore, the power of the High Court under 482 cannot go beyond, is restricted or limited to the extent of the provision under the statute. And if it is a non-compoundable case, then the High Court's power is restricted. Supreme Court said that no, 482 starts with the non-obstantia clause, which mentions that notwithstanding anything contained in the CRPC, the inherent power of the High Court cannot be restricted or limited by any provision under the Act. And so therefore, it said that even if it was a non-compoundable offense, if it was filed by consent, and if the ingredients for quashing were made out, then the High Court could exercise its right of quashing, and that power would not be limited by Section 320. Later on, Justice Markandeya Kaju took a different view and said that this needs to be discussed in which type of cases consent can be given. And therefore, in Gyan Singh, Justice Loda has delivered a classic judgment in which he has considered all the case law. I would request all junior lawyers to go through that judgment. It's a very elaborate judgment considering all aspects. Go through R.P. Kapoor also, Bhajan Lal, and Gyan Singh. And Supreme Court, but then added a rider. Supreme Court held that B.S. Doshi was the correct law, and the power of the High Court was not restricted or limited by Section 320 of the CRPC. And therefore, but it laid down the rider that in serious cases, this could not be done. Later on, recently in 2014 or 15, another judgment has come, judgment in the case of Narinder, where the Supreme Court has again examined the law and has reiterated principles under which a complaint can be quashed under 482 or under Article 226 of the Constitution of India. So I believe that this we have extensively considered the provisions. There are several other facets, but I believe that we don't have the time. The 1 hour is over. I am quite sure that you would like to ask some questions so that we have an interactive session. So thank you very much for giving me a patient hearing. I give the mic to the host who can then ask me the question on behalf of the other participants. Thank you very much.
Thank you so much, sir, for an insightful session. I am sure our viewers now have a clear view about quashing a criminal complaint. And interestingly enough, a lot many questions have poured in for you, sir. With your permission, I would like to begin with them, sir.
Yes, please do that.
So the first question is from Advocate Sagar Shah. He asks, if the quashing of FIR is filed and subsequently a charge sheet is filed, what would be the effect?
Now, you see, normally, the general rule is that if the charge sheet is filed, the High Court normally doesn't interfere with the quashing of FIR. But then the remedy is that if you file a complaint for quashing of the FIR, you should take an ad interim order and request the court to protect him that no charge sheet should be filed till the quashing petition is decided. But in rare cases, even if charge sheet is filed, the High Court, if it is convinced that it falls under the categories mentioned by me earlier, it can even quash the FIR and the charge sheet which has been filed. So there is no specific bar. The power of the High Court is not limited, and the High Court can exercise its discretion. So that is my answer.
Okay, noted, sir. Next question is from Advocate Surel Shah. He asks that it is not a secret anymore that a complaint is drafted by an advocate, wherein all facets of a section are cleverly included. How does the Honorable High Court judge dealing with the quashing complaint find frivolity in the complaint?
Now, I must point out, just as the defense counsel is ingenious, even nowadays the prosecution or the police have also become ingenious. They know the judgments of the Supreme Court and the High Courts, and accordingly, complaints are drafted. It depends on the astute judge to find out the grain from the chaff, separate the two, and find out what is the malignant part and remove it accordingly. So it's a great test for a judge to see what is right and what is not right, and whether that complaint would test uh, would be end up in a conviction or acquittal, or there is no case made out at all. So that depends. There are no hard and fast rules as to how a judge can. He has to rely on the judgments of the Supreme Court, find out the facts. There is a lot of number of judgments where they have held that at this stage, the documents which are produced by the accused, unless they are unimpeachable, cannot be relied upon. In cases particularly of criminal breach of trust, then under section 420, cheating, sometimes the accused tries to rely on documents. Secondly, there can't be any appreciation of evidence at that stage. And keeping in mind all these principles, the judge has to apply his mind and take a decision.
Sir, the next question is from Dr. Narendra Javale, and he asks, after quashing of an FIR and IPC, especially under section 498, 420, 376, how can the loss of time, financial loss, defamation, social status loss can be recovered? Is this not a violation of human rights?
Yeah, it all depends. And for vexatious litigation, filing a vexatious proceedings. But normally, whenever such complaints are filed, and if it is filed by consent, care is taken by both lawyers to ensure that after the complaint is filed, is quashed, no coercive steps will be taken by the accused. And even in otherwise, merely because a complaint is quashed, that does not mean that what the court has held gives him a right for malicious prosecution, unless the court gives a finding that this is a patent case of malicious prosecution. And there are provisions, there are acts which empower the accused to proceed against the complainant under those provisions. And if done, the court will then decide whether he should be compensated or not.
Yeah. Sir, the next question is from our very own advocate Priyanka Rane Patil. And the question is, if a complaint is quashed by holding that it's false and fabricated, can we ask for compensation? And what are the other remedies that can be sought for?
Can we, what is the question? Sorry.
I'll repeat it, sir. If a complaint is quashed by holding that it's false and frivolous, and can the person ask for compensation or any other remedies that can be sought?
I believe that there is no bar. If there is a finding given that is a false and fabricated case, for the accused to take recourse to these remedies of compensation. But then, see, normally, if that happens, the other side will go in appeal to the Supreme Court and the litigation will proceed. And there are very few cases, at least known to me, where compensation is asked for if the complaint is quashed.
So, one final question. Sir, can documents which are undisputed be considered for quashing of a complaint? To what extent can the court consider these documents?
See, there are several judgments of the Supreme Court on this point. As I pointed out earlier, unimpeachable documents Supreme Court has held can be considered while deciding a complaint for quashing. If those documents are admitted, surely the High Court can examine those documents. But if they are disputed, then unless they are unimpeachable, now what are impeachable documents and unimpeachable documents has been discussed by the Supreme Court. I don't have it ready at hand though all those documents instances as to which documents are unimpeachable, which are not. You have to refer to that judgment. But that is the law laid down by the Supreme Court.
Thank you so much, sir, for graciously answering these questions. I now hand over to Advocate Chirag Sonecha for a vote of thanks. Thank you, sir.
Thank you, Pooja. Sir, on behalf of Sangli Bar Association, Advocate Vasantrao Patil, Lawyers Training Center, I take this opportunity to extend sincere gratitude for the time and effort that you took to share your thoughts and experience with the audience. Judging from the comments of those who attended, the webinar has been very successful, and all the credit goes to you for delivering such an interesting session on quashing of criminal complaints. So, your lecture was very informative, and I am sure each one of us has learned a lot from today's session. Thank you. Thank you very
Thank
much,
you.
sir, for sharing
Thank
your words of wisdom. Sir, we also hope that you want to be involved in our legal training center program, and we earnestly hope to see you soon on our platform delivering yet another insightful talk. I once again thank you very much on behalf of the whole team of Sangli Bar Association, Advocate
you.
Vasantrao Patil, Lawyers Training Center. I would also like to thank the whole team who has been relentlessly working in the background to make this happen. I also thank everyone who attended this seminar. Sir, with your permission, shall we now conclude the webinar?
Thank you. My privilege and my honor to be here. Anytime I'm ready to help you and all your junior lawyers.
Thank,
Thank you. Thank you.
thank you, sir. The webinar
Thank
is
you.
hereby